I said we'd look at the documentary evidence and support the proposition that the judge's factual findings as understood by the appellants are the only factual findings that are not wholly inconsistent with the documentary evidence. And to that end, if you could please take up the appellant's bundle of additional documents. And if we could please begin at tab 45, and it's at the bottom, page 176. Right at the bottom we see that this is Denise Chen of S.J. Berwin, advisors to Equity Trust, emailing Matthew Corwin of BDO, and over the page the paragraph, full paragraph, the last sentence, on HIVOB, it is likely the properties will be distributed at a value of 226 million. So that's two days before, shortly before the acquisition, and obviously at that time the 226 million figure would seem unobjectionable because it was proposed. The proposal was that there be a HIVOB shortly after the acquisition, as the judge refers to in paragraph 33 and paragraphs 2 to 9 of his judgment. Then if we go to tab 51, page 225, and the lower half of that page is an internal S.J. Berwin email, 12th of October 2005, sent on behalf of Heather Corbin, a name that features subsequently, and we see at the bottom of the page we've already agreed with Olswangs, that's in their capacity as solicitors for Minerva, the value at which the properties are to be transferred, assuming the liquidation takes place within 12 weeks of completion. The agreed values are 78 million for Ludgate and 146 million for Sampson, and this is what must be shown on the property transfers. That's if it's within 12 weeks. Then if we go, please, to tab 56, 234.
I'm sorry, that was tab 56?
Well, the last one was from Heather Corbin at S.J. Berwin to whom?
I understand. Sorry, is it Mr. Page? Well, I think he's S.J. Berwin as well.
It's an internal S.J. Berwin.
Internal, yes, thank you. Then if we look at tab 56, page 234, this is an email that the judge describes as being sent to a prospective purchaser. Mr. Brown's copied in. This is Angela Morris at Equity Trust, sending through the values of the properties in the trust. She notes that these valuations were paid on the instruction of the banks and would therefore be done extremely conservatively, and they would look to value the properties at 20 to 30% of their current market values. The first one's Newcourt at 72, and then the fourth one, bank side properties, 247 million, based on the August 2005 valuation. Then if we go to tab 57, page 236, Matthew Corbin at BDO, emailing Angela Morris at Equity Trust with Mr. Brown copied in. Sounds a note of warning. This is the second full paragraph. Sorry, we begin at the first full paragraph. He notes the two bankside properties were acquired for 226 million in August 2005. The correct figure is actually 229, as the judge records. The next paragraph, the current CGG exposure rises as a result of the IPO valuations of up to 295 million, an uplift since acquisition, therefore 69 million. Assuming this uplift did become taxable, then there's potential CGT liability in HIVOB of about 21 million. We do not know how much this liability is covered by the original share purchase agreements with Minerva, and this is what we will need S.J. Berwin, Heather, to consider. Then tab 63, page 249. This is a draft document prepared for the proposed IPO of the companies in the INSR Trust. And we note in the left-hand column, in the middle paragraph, we note that the directors intend to hive up the properties at the value for which they originally acquired them, on the basis they consider the values to be consistent. This would result in no CGT becoming payable. Then notes, however, we note the indicative valuations prepared in advance of the potential IPO show an increasing value of, and that's figures we've already seen in the email, and that's a draft from the 6th of April 2006. And then if we could please go to tab 65, which is, in my submission, a particularly important document. Its date is the 18th of July 2006.
So which page are we going to?
We're on page 251, my lord.
I can't see the date.
There isn't a date on it, I'm afraid.
Oh, good, I'm glad.
You told us it was what?
I didn't want to volunteer that information in case I was wrong. But no, I couldn't find one. It's the 18th of July. Sure, it's about 2 weeks before the transfer. And this has been sent to Equity Trust. The Andrew there is Andrew Pollard, the name which appears in the judgment. And the partner is Heather Corbin at SJ Bowen, the name we saw in the emails previously. And if we could just look over the page for the moment, we see that Claire Smith, it's another name that features. Claire Smith is copied in. So the important, just before we look at the detail of the letter, the importance of this letter sent to Mr. Pollard is that Claire Smith, on the 28th of July, 4 days before the transfers, has a meeting with Mr. Pollard and with Mr. Sirra for the purpose of advising them as to the transfer price figures to use. And the judge proceeds on the assumption that the advice that would have been given in that, in that conference call, the advice that would have been given in the conference call was the same as the advice that was set out in this letter. Now, when we look at the letter, if we go to the third paragraph, and this is dealing with the transfer of Ludgate and Sampson properties, it says, since the UK companies do not have distributable reserves, my understanding is that the property needs to be transferred up to the Jersey company at market value. And that's the sentence that the judge focuses on. But when we read on, however, a price above 148 million will not be protected by the share purchase agreement. That's a reference to the tax indemnity. And this should therefore be considered in determining the relevant market value. So obviously we say, that is SJ Bowen, saying that yes, you need to transfer at the market value, but when you're deciding what the relevant market value is, you should keep in mind that anything over 148 million falls outside the tax indemnity. And then moves on to Ludgate. In relation to Ludgate,
I'm not sure what point you're making about that. Are you saying that Ms. Corbin was saying that you could take a figure closer to the indemnity figure, which wasn't the market value?
well,
Is that how this is to be interpreted?
this fits in the basis.
Being dishonest?
Yes, we say that when you look at the judgment, this is the judge. The judge is considering whether the figures used fell within a range of justifiable market values. He doesn't concern himself with whether the choice within the range was influenced by the tax indemnity. And when we look at what the judgment says about this letter, it simply refers to SJ Bowen reminding them that the transfer prices needed to be the market value, and ignores the part where it's SJ Bowen say, immediately having said that, a price above 148 million will not be protected by the tax indemnity, and this should therefore be considered in determining the relevant market value. Now, obviously, our submission is, when you determine the relevant market, you have to set aside entirely what the limit of the tax indemnity is. It's irrelevant. The market value is the market value.
So this is erroneous advice, not dishonest advice? Was Corbyn being dishonest in saying that?
Well, the dishonesty or otherwise of S.J. Bowen was not investigated in circumstances where I don't know the extent to which they had focused their minds on the representation that would be made to HMRC.
But you are suggesting that if Mr. Brown took that into account in choosing something that he wouldn't otherwise have chosen as a market value, that would not only be erroneous but was dishonest. If that's true of him, why is it not true of Ms. Corbyn?
Well, one might expect S.J. Bowen to be aware of the terms of the representation that was to be made to HMRC, but there's no actual consideration as the extent to which, by giving this advice, they were overlooking the terms of the representation that would be made to HMRC.
Let me put the point in a slightly different way. If what Mr. Brown was doing was what he was advised by S.J. Bowen was legitimate, would that be relevant to whether he was acting dishonestly or not?
Well, my lord, this comes back to 2 points on that. Obviously, there's no suggestion of any reliance on legal advice for him doing what he says he did. Comes back to the pleading point. His case was simply, I got an independent valuation. No suggestion, but I just did what S.J. Bowen said I could do. That's obviously the first point. And the second point is, given his knowledge of the terms of the representation, that he was representing that he believed it to be the true market value, then he should have appreciated that the advice he was being given was inconsistent with the representation that was to be made to HMRC.
Thank you.
So the same observations are made with respect to Ludgate, since the same principles apply to Ludgate as above. Then at tab 66, page 254, it's the second page in the tab. We see at the bottom there, 20th of July, Mr. Pollard at Equity Trusts asked Mr. Corbyn at BDO, is valuation something you can assist us with? And then if we go back to page 253, Mr. Brown of BDO responds, Matthew's passed the letter over, the SGB letter. He says, neither this office or our colleagues have the expertise qualifications to value property. You will need to instruct someone like Collier's to carry out the necessary evaluations. The letter makes the point that high hopes above a certain value will create gains subject to UK corporation tax. We've always understood this to be the case. And then, if we go to tab 67, 256, it's the middle of the page, Mr. Pollard emails Sarah at Buckingham on the 26th July saying, I had an idea you were going to provide the valuation. Top of the page, this is the email the judge has referred to. Andrew, I will need some guidance as to which side of the range to err on. I will discuss this with Claire Smith. Claire Smith has been copied in on the 18th of July State Bowen letter, as we saw. If we go then to the next tab, page 259, this is the beginning of the email chain. The email there Claire Smith of S.J. Bowen to Harry Sirra and Mr. Pollard. Could I have your availability for a conference call for tomorrow afternoon on the value of the hive of the properties, please? Let me go back to 258, bottom of the page, continuing the email chain. Mr. Sirra says, Claire to Claire Smith, I'm available anytime. Before the call, please can you let me have the upper threshold of value beyond which a capital gains tax charge crystallises. And above that email is Ms. Smith's response. Harry, Andrew, I was just waiting for dialing details, but I've arranged a conference call for 3 p.m. today, 28th of July, and we'll send you the dialing details when I receive them. The upper threshold values for capital gains tax purposes are 78 million for Ludgate and 148 million for Sampson. Then, above that, Mr. Sirra responds, thanks, Claire. Read the upper thresholds. The figures below add up to 226 million. We paid 229 million. My memory is not that very clear on this, but we have some recourse to Minerva, ? And Ms. Smith, top of the page, responds, 229 million was paid for the shares, and the base cost indemnity for which there's recourse to Minerva is for 226 million pounds. Applied, they're supplied without comment. And so that's the documentary evidence on this point.
And there was a call at 3 o'clock or whatever, which had S.J. Bowen on it as well. So.
That's the assumption that the judge works on. We don't have a problem with that. As we'll see when we come to the judgment, the judge assumes that the advice that was given at the conference call, on the conference call accorded with the advice in the letter of the 18th of July. We say, having seen the documentary evidence, there is nothing to displace the obvious inference that the figures of 78 million and 148 million were chosen because they were the upper limits of the Minerva tax indemnity. On the contrary, it is implicit in these exchanges and expressly stated in the S.J. Bowen advice that the tax indemnity can and should be taken into account and influence the transfer prices chosen. And we would also say that if my learned friend's interpretation of the judgment is the correct one, then it was utterly perverse of the judge to have decided that the figures in the tax indemnity did not influence the choice of figures that were used for the transfer prices. So we say all the judge is interested in, when we come to judgment, all he's interested in is whether the figures that were used could be said to be justifiable within a range. So his question then about the coincidence with the tax indemnity is whether the figures were purely set by reference to the tax indemnity. And obviously he's found they weren't set purely by reference to the tax indemnity because the judges found that they came within a range of justifiable figures, which to him is the only relevant question. So if we could then turn to the judgment. Beginning at paragraph 222. Just for 222 follows on as reference to the previous college valuation at 80 million. 222 records the acquisition cost was in fact 78.5. So the judge is aware that the figure that is being chosen for the transfer is actually less than the acquisition cost. And at 223, there's the recognition that contrary to what he pleaded, Mr. Brown accepts in cross-examination and in broad terms he was aware that prices were rising in 2005 to 2006. Then 230 is where we find the first reference to the BDO letter. Second sentence, advice was sought from SJ Bowen, who advised on the 8th of July that Ludgate House and Sampson House needed to be transferred at market value, but also drew attention to the fact that if the transfer price was in excess of 78 million, that it would be corporation takes of cash to pay on gain in excess of these figures. It's not, we would say that's not quite what the letter says, but he returns to it more fully later. 231 concludes with a reference to the email that's previously referred to at 122. Mr. Pollard emailed Mr. Searle suggesting Buckingham would provide an evaluation. Mr. Searle's response that he would need some guidance as to which side of the range to err on, as well as saying he would discuss the position with SG Berwin. 234. Based on this correspondence, it is my view more likely than not that Buckingham gave advice on the value that should be used for the purposes of the transaction. Again, not advice as to what the market value was. 235, it's a small point that we note. Buckingham are asked subsequently if there was a valuation, no valuation was completed at the time of the transfer of Ludgate House. So Buckingham are asked, do you have a valuation? And they say they do not. Judge notes that's not inconsistent with Miss Searle providing verbal advice on the conference call, which has specifically been arranged to discuss the valuation issues. Then at 237, reference to the balance sheets that were prepared ahead of the transfers. The balance sheet showing the value of Ludgate House as 78.5 million, and referring to the fact that a sale at a price of 78 million would obviously reduce the net assets to 270. We'll come back to that in due course. 240, the judge says, I accept that the evidence shows that the question of tax on capital gains was firmly in everybody's mind at the time of the discussions relating to the proposed transfer of Ludgate House.
Just before we get 238. Claimants invite the court to insight the purchase price for Ludgate House was set purely by reference to the Minerva capital gains tax indemnity figure.
Thank you.
Was that your submission?
That is my submission, yes.
And that's the submission he rejects?
No, was that my submission? No, that's the basis for the submission I'm now making. Sorry, as we see the pleaded case is the figure was set by reference to. No, purely. Because as arose after this morning, we say that if using the language from Hayes and Palumbo, if the choice of figure is influenced by tax considerations, that is dishonest. That's not a genuine and honest assessment. So we've said it's set by reference. They're the same figures. We've looked at the documentary evidence. They've clearly been taken into account. But the judge introduces this notion of the figures being purely by reference, because the judge then simply asks himself, were they taken from a range of figures that were thought could be justifiable? And because he ultimately concludes that they were, he's untroubled by the fact that the tax indemnity clearly played a role in the selection of those figures. Now, we then go to 241. And this is where we say, bearing in mind the terms of that letter, unless the judgment is as we interpret, there's a serious mischaracterization of the advice that S.J. Bowen gave.
We've skipped over 239, in which the judge clearly does reject the inference which he's recorded you as inviting the court to make.
Yes,
At
sorry.
238.
But it's set purely by reference. He says, no, it's not set purely. And
And
I don't
that
read too much-
you say mischaracterised your case.
yes. And it says the position is more nuanced, which I may be reading too much into that. But again, when we say we're not quite sure where the nuance comes into it. He says, well, I'm not saying that the tax indemnity wasn't a factor. It's more nuanced. It wasn't purely, the figures weren't set purely by reference to the tax indemnity. Because he then goes on to discuss the use of a range again. Now, 241, Mr. Nobby points out the clear advice from SJ Bowen in July 2006 is that any transfer had to take place at market value. With that pausing there, that's true. And then to go on, irrespective of the limit of the capital gains tax indemnity. Well, it's not quite what it says. It specifically says that they should consider the limits of the tax indemnity when considering what the relevant market value is. Then, see, this is the point again. Therefore, contrary to the submission made by Mr. Parker, the need to set the price of the transfer of Ludgate House by reference to market value was also firmly in people's mind. So the advice letter that we saw has got two parts. It needs to be the market value, but when deciding on the relevant market value, keep in mind the tax indemnity. He ignores that second part. And I submit that's because all the judges, the judge thinks he needs to find is that the figure was a justifiable market value. And then 242. Taking account of this, it is my view more likely that Mr. Sirra did indeed advise that 78 million was an appropriate market value to use for the purpose of the sale to LPH. Mr. Parker suggests this is implausible, given that Mr. Sirra knew the total cost of purchasing 24 Blackfriars and therefore was Ludgate House of 78.5, and the values have been increasing in the meantime. However, it is clear from Mr. Sirra's request for guidance as to which side of the range to err on that he considered that there was a range of possible values, all of which could reasonably be said to be the market value. So again, it is sufficient that the figure being used is one that could reasonably be said to be the market value selected from a range. So the judge does not then, apart from, we'll come on to 244, he doesn't then consider whether the choice from the range was influenced by the tax indemnity. Even though we say on the documentary evidence that the court has just seen, it obviously was. And then 242, you say, obviously, end of 242, all of which could reasonably be said to be the market value. And at 244, as we've noted, Mr. Norbury pointed out in his closing sentence, it was very surprising indeed if the transfer price which emerged from a conference call with the solicitors acting in relation to the transaction who advised the transfer price must be the market value was not expressed to be the market value, but was a figure chosen purely to avoid tax on gains which would otherwise result from using a higher figure. And then we have the word again, 245. Although Mr. Parker sought to distance the claimants from any questions to whether Mr. Pollard might also back to doing, it is impossible to escape the conclusion that if the price had been set at a figure which was designed purely to avoid any tax liability, which is not thought to represent the market value of Ludgate House, Mr. Pollard must have been complicit, etc. And then at .248, in light of this, it would be very surprising if Mr. Pollard was willing to recommend to Brown and Mr. Leonard a sale of Ludgate House at a price of 78 million, if he did not think this was justified as being the market value. But that's got to be set, of course, against the second half of 242, when the judge had noted that it was clear from Mr. Sirra's Sirra's email to Mr. Pollard, requesting guidance as to which side of the range to err on, that he considered that there was a range of possible values, all of which could reasonably be said to be the market value.
Well, on the face of it, 248 says he thought this was the market value.
The market value on the face, that's probably right, my lord. If that's all there was, but we say that paragraph's got to be read along with all the other paragraphs where he discusses the basis for the figures that were being used.
Mr. Brown gets his figure from Mr. Pollard, doesn't he?
Well, that's then. Yes, that's 250.
I mean,
250.
He's no longer in charge of the account at this stage, so although he's still a director and
That's
has to get the figure. So
250.
if Mr. Pollard thought that 78 million was the market value, this is for supposing that
Well, my lord,
Mr. Smith in adopting that, and Mr. Brown in adopting that figure didn't have the same.
well, that might be the case, but paragraph 250 is the judge dealing with this aspect of it. It is accepted on both sides that Mr. Brown would have discussed the position with Mr. Pollard, who would no doubt have informed him of his discussions with Mr. Sirra and S.J. Berwin. I accept the question of tax on capital is likely to have formed part of their discussion. In the findings I have made, Mr. Sirra's advice that 78 million was an appropriate figure, phrase again, for the market value would also have been relayed.
So that's a finding, is it, that what Mr. Pollard said to Mr. Brown is that 78 million is the market value? I misread that.
Well, the discussions that Mr. Pollard had with Mr. Sirra and S.J. Berwin were in accordance with the advice that S.J. Berwin had given, which was, when deciding on the relevant market value, you should consider the figures from the tax indemnity. And they are using the figures from the tax indemnity.
I mean, you've got to fit 248 into this. At first sight, 248 signifies that having had exposure to all these things, Mr. Pollard thought that this was the market value. You challenge that.
Yeah, my lord, yes, we do, because we say, reading the judgment fairly, I mean, and again, bearing in mind the judge's own interpretation of his judgment on the supplementary, on the permission to appeal application, the word justified is the same concept that is being used throughout as to something that's justifiable, being a figure taken from a range, according to the purposes of the transaction. To read this as saying that Mr. Pollard believed he was being given the true market value is to disregard everything that's gone before.
So we have it that Mr. Brown is given the figure by Mr. Pollard. If it were right to read 248 as meaning that Mr. Pollard thought it was the market value,
No,
then Mr. Brown is being given the figure that Mr. Pollard thinks is the market value.
but my lord, yes, but what we say is 250 is simply inconsistent with that interpretation of events. The 250 is saying that Mr. Pollard would have informed Mr. Brown that Mr. Sirra has selected a figure from a range, and that S.J. Berwin have advised they should keep in mind the figures from the tax indemnity.
I mean, there are two possibilities on the face of it there. Either Mr. Pollard has concluded that this figure is the market value and is telling Mr. Brown some interesting background in circumstances where, for whatever reason, he's concluded it's the market value. Or, which I think is what you're suggesting, well, really, he's not saying it's the market value. He's telling Mr. Brown all these interesting things and revealing the fact that it's not the only market value.
Well, yes, because again, I don't understand to be suggested that the findings with respect to Carey Street are different to the findings with respect to Ludgate House. So we've had for Carey Street, we've had the discussion of Mr. Brown's use of a range with figures, the figure changing according to the purpose in the context of Carey Street. That background is carried over, obviously, into Ludgate House. And we've had, the judge doesn't, and we've had the judge emphasising that Mr. Pollard knew that Mr. Sirra was selecting a figure from a range on the basis that Mr. Sirra thought there was a range of possible values, all of which could reasonably be said to be the market value. So Mr. Pollard knows that, and there's no recording of any event that would lead Mr. Pollard to think, despite that, Mr. Sirra is telling me that he thinks this is the market value. A fortiori, when subsequent to the email, which tells Mr. Pollard that Mr. Sirra thinks there's a range of figures, all of which reasonably could be said to be the market value, they've had the discussion with Claire Smith on the 28th of July, who's told them that when deciding on the relevant market value, they should consider the figures in the tax indemnity.
Does it follow, therefore, that Mr. Pollard was also acting dishonestly?
I do not know what Mr. Pollard's understanding was of the representation that was to be given to HMRC. That's critical to all this. If somebody were to say, that I just thought what was necessary and what was needed was a representation that the figure you were put forward was arguable, then it's not dishonest. If you import something after a holiday from the European Union, and you then have to declare what the value of it is, you can always say, well, I don't know, I'll put it on the low side, because they know that I'm putting this on the low side and they don't mind. If that was your position, you could say, I'm not deceiving anybody.
Mr. Pollard is in the same position now as Mr. Brown was earlier, so far as tax was concerned, in managing these affairs. And I find it rather surprising submission that Mr. Pollard would not have known that the transfer price
My point,
in a hive-up would not have to be declared as the price with the usual declaration to HMRC.
But my lord, council obviously cannot make serious allegations against people when they're not there. We had warned Mr. Pollard that the action might trespass under questions of his integrity should he wish to become involved, and he didn't. But for the purposes of my case, it wasn't necessary for me to make allegations based on precise findings as to what Mr. Pollard may or may not have known.
I understand that, but the point the judge made, and in 245, and I agree he made it by reference to the indemnity figure being purely set by reference to the indemnity figure. But the point would be the same if he'd said influenced by the indemnity limit.
Because the
point the judge was making was that the consequence of your argument, even though you didn't have to make the accusation, the consequence of your argument would have been that Mr. Pollard must also have been acting dishonestly. And speaking for myself, that does seem to me to flow.
Well, if one assumes, I'll come on in a moment, if one assumes that Mr. Pollard knew the terms of the representation that was to be made to HMRC, and if one assumes that S.J. Berwin knew the terms of the representation that was to be made to HMRC, then I agree.
I mean, one thing you can be absolutely sure of is that the tax solicitors at S.J. Berwin knew the terms of the representation.
Well, again, in proceeding on that basis, then we come into the point that was emphasised in Hayes and Palumbo. Questions of honesty or dishonesty are not determined by the views of a particular market. Now we're dealing with the tax-saving industry. Now I say we don't need to go there because there's no reliance on S.J. Bowen's advice as being an exculpatory factor. But if we do go there, then one's inclined to say, well, it may be that they all thought there was nothing wrong with using a figure taken from a range for tax purposes. Just like it appears with the LIBOR Euribor cases, there was an awful lot of people seem to be happy to do it. But it doesn't matter, it doesn't matter. If you know the terms of the representation require you to believe it is the market value, and you're putting a figure that you do not believe to be the market value, but simply chosen from a range of possible market values influenced by the tax considerations, then you're dishonest.
All right. I quite follow where your submissions go. At some stage, I might like to identify the sort of core legal point, which is something along the lines of, well, I'm making it more specific than it perhaps needs to be, but if a director of a subsidiary company adopts a figure within a plausible range of market values, choosing a low figure with a view to minimizing tax, even if the parent company is quite happy with that, he necessarily acts in breach of his duty to act in the interests of the parent and necessarily is dishonest. I mean, that's the core of your submission, really, isn't it?
Knowing of the representation to be made, yes.
Yes. I mean, he doesn't have to know the detail of the representation. I mean, it's obvious that the figure is going to be reported to the revenue.
Well, as I say, one could posit a situation where the director says, everybody knows what happens. Everybody knows that we're just picking the lowest figure we can get away with. It's not what we actually believe is the target. You know, everybody knows that. They challenge it or they don't. But I'm not deceiving anybody. That could have been the case run here if that had been Mr. Brown's view of the representations to be made. But Mr. Brown says, no, that's not the representation that's made. I agree with the claimants. The representation is that the transfer price is believed to be equal to the actual market value. And Mr. Brown said, and I thought it was because I obtained an independent valuation. And the judge then goes off. I mean, obviously we complain, this is the fourth challenge. The judge goes off and says, oh no, well, this is all about a range. But doesn't then say, well, how does the range fit in with the representation that Mr. Brown admits he knew would be made? And the answer is, it doesn't. Because you don't have a belief, as you need to for the representation, that this is the true market value. And again, 251, the judge emphasises that it could not be inferred that Mr. Brown knew that the market value of Ludgate House was in excess of 78 million. And again, we can't criticise the logical inference, but the question isn't, for these purposes, did he know that the market value was in excess of 78 million? The question is, did he believe the market value was 78 million? And the answer to that is no. He just thought it was a figure that could be justified as being within a range of possible market values, which is why it was okay to take the figures from the tax indemnity. And the judge, what we've read, the judge doesn't explore why you happen to have figures that are exactly the same as the tax indemnity. Particularly in circumstances where the 148 million for Sampson House is not a figure that anybody's ever used otherwise than by reference to the tax indemnity. And you've got a valuation of Sampson House at 204 million. It's not a coincidence that the figure's 148 million. It's obvious it's not a coincidence. But the judge just ignores the fact that they're exact match because, as I say, he just thinks it's sufficient that the figure falls within a range.
I'm just coming back to something I said this morning. Supposing that you were right that the judge hasn't addressed this, I have to say I would have thought the logical consequence would be a retrial.
Well, unless this thought that it was implicit in the judge's use of the word purely on 3 occasions, that he was accepting that it had been a factor. Because he introduces the word purely, because it is self-evident from the documentary evidence that it was a factor, but the question the judge asked himself, was it purely the tax reference, or was it also these figures fell within an acceptable range of reasonable and possible market values?
And just completing the point, so supposing that one could infer that the judge approached things that way, one would have to face up absolutely clearly to the proposition of law I was putting to you a moment ago. One would have to work out for sure what the answer to that was.
That the dishonesty vis-a-vis a third party makes it a breach of duty.
In circumstances where it is in the parent's interest
Yes.
to have the transaction, you are choosing from a range of possible market values.
Yeah, the critical point is the dishonesty as against HMRC, and we're going to be looking at digging out some authorities.
Yeah.
Because we say at this stage, we would, just to flag something, I mean, the court may think that this is something that needs further exploration, but we would submit it's not for this court, because there's no objection taken at the trial to our notion that dishonesty as against HMRC was sufficient for the purposes of our case. So just to make good the point that our pleading did not use the word purely, if we could go to, this is our tab 10, it's at 16.2 BC. Sorry, page reference.
Is it 180?
It's page 180, tab 10, yes, so thank you, sorry. You see at the bottom of the page, we say the value to be used for the hive-up was set by reference to the extent of the tax indemnity. And we did not say, and nothing else. So the judge's answer, well, it wasn't set purely by reference to the tax indemnity. It was a figure within a range of, we say, doesn't actually meet the point.
It's a bit
If it-
harsh though, Mr. Parker, isn't it? Because if someone says something is set by reference to something else, you think that that is the link between them. That is the link between them.
Well, it
The
is,
market
there is,
value.
yeah, my lady, but that's the point. We say, there clearly was, you see the documentaries, clearly there's a link.
No,
But
but by reference to, when you plead it at little c, does suggest that it is the link. When you see the judge going off, as you say, on a frolic, they're saying, well, it's not purely that.
Yes.
But when you read set by reference to, that's the bell that it rings in your mind. Would it not?
And we say that this plea is borne out by the documentary evidence, borne out by the S.J. Bowen letter, There's no answer to say.
No, I'm just making
Yes.
the point that by reference to could mean solely by reference to, without the solely being there. And you're saying, in order to get to the purely situation, I would have to include solely or something like that. And by reference to is a much wider
Yes.
scope. That's the difference.
And
That's
okay, sorry, getting to pleading points, of course, if they come back and say, no, it wasn't purely, it was also set by reference to a figure from a range, which Mr. Brown could consider to be, we'd have said, by way of reply, so what?
Sorry, go on.
In relation to Sampson House, was the case you advanced at trial, that the figure was taken solely as the upper limit of the indemnity? I imagine from what you've been submitting to us it was, because you've been saying it was so far away from any of the valuation figures that it can't have been regarded as within a range, and that shows that the
Well, again,
upper limit of the indemnity was uppermost in their mind, to put it neutrally. But so far as Sampson House is concerned, was it your case at trial that was, by reference, the upper limit of the indemnity, meaning purely?
well, I think that would have to be fair in circumstances where the only other option was a belief in it being the true market value, which seemed rather absurd in with a valuation of 204. We're going to say, if the judge is then going to bring in the notion of a flexible concept, then he should be exploring with me, are you saying, Mr. Parker, that if the figure was influenced by the tax indemnity, but he was choosing from a range of figures, are you saying you still maintain your case? And the answer would be yes.
Well,
Because
I'm sorry to interrupt you, but I can quite see that forensically you would be arguing it's an amazing coincidence that both these figures are at exactly the upper level of the indemnity from Minerva, which suggests that that's what drove them. And look at Sampson. They couldn't have been chosen on any other basis, because if you look at the values, they're way out. And you should infer the same so far as Ludgate House is concerned. Was that roughly the way the argument went?
yes,
But
not as eloquently, obviously.
well, but that would mean, I think, that the judge would not have been mischaracterising your argument on Ludgate House in saying your case was that it was chosen purely by reference to the upper level of the indemnity.
Well, my lord, this comes back to the pleaded case. My submissions were predicated on the defence that was being put in opposition. There was no suggestion that there was any other relevant factor. The point at which the judge says, but there is another relevant factor, is the point at which I say, but that's irrelevant. It is still being set by reference to, as pleaded. Basically, in other words, if the judge says, well, actually, the dishonesty wasn't exactly as you said, because he dishonestly chose the tax indemnity figures because they were within a range, in my submission, that doesn't mean my claim fails. You can't set up, by way of a successful defence, a defence that's still dishonest, still based on dishonest conduct. There's a slight wrinkle to your allegation, Mr. Parker, because I think they used a range. Okay, well, nobody's suggested that they used a range, but okay, Judge, but the allegation is still made good, because you can't be influenced by tax considerations, and they clearly were. And that's why you, Judge, haven't commented on the obvious coincidence between the figures, nor have you actually bothered to mention that the S.J. Bowen advice was on the basis that they should consider the tax indemnity figures when choosing the relevant market value. It just ignores all that. So what we say is the only qualification to the truth of our allegations was that the judge found the transfer price had been set by reference to a tax indemnity from a range of justifiable market values. But that was still dishonest as being inconsistent with a genuine and honest assessment of the market value regardless of the amount of tax that would need to be paid. And indeed, and it reminds me that none of this was explored because, as I've said, Mr. Brown was simply saying, I got a valuation. He's saying the tax indemnity had nothing to do with it. I got a valuation. So, and then, as we've made the point, 252 of the judgment, where the judge prays in aid Ludgate House, he just ignores the difficulty that Sampson House gives rise to. And that's why we say that if, in fact, the judge was saying this wasn't in any way influenced by the tax indemnity figures, this was a genuine belief as to the market value, then we say it's perverse. The documentary evidence shows they were using the tax indemnity figures, and it's perverse because they've got a valuation that the judge says Mr. Brown would have had in mind of Sampson House at £204 million, and they've got nothing supporting the 148 million. And on the contrary, they've got previous statements from Mr. Sirra that the properties were worth considerably more. Now, subject to anything else that your lordships or my lady may have on that particular point, I was going to move on to the second challenge. Obviously, the second challenge is the judge ignoring the evidence of Mr. Brown's dishonesty, even that which was implicit in his own findings, consistent with the judge viewing the possibility of Mr. Brown acting dishonestly, as, quote, inconceivable. And the reference to inconceivable is in the judgment at paragraph 136. And we say the judge's starting point, that dishonesty on the part of a professional man for any other reason than direct financial gain, his starting point that was inconceivable, seems to have caused him to disregard any evidence that showed that Mr. Brown had indeed been dishonest. And this error undermines the judge's decisions on all matters relating to Mr. Brown's liability. And it undermines his assessment of Mr. Brown's honesty in the witness box. And in particular, particularly egregious is the fact that the judge doesn't consider the dishonesty evidenced by the minutes of the transfer of New Court, which are in the supplemental bundle, tab 5, page 52. And this is a document that will feature in my submissions on blind eye knowledge, which is why I'm taking this particular point in the sequence of the challenges. So this is a document.
Sorry, which page?
Page 52,
52.
tab 5.
Yeah.
Just to put this document in context, the appellant said these minutes were deliberately misleading as they showed Mr. Brown pretending that he'd set the price by reference to an independent valuation when he had not. The respondents said that they were honest minutes accurately recording the board's reliance on an updated valuation by DTZ. And the minutes were therefore the litmus test of Mr. Brown's honesty or otherwise. And we can see that item 5, the chairman noted the company had received valuable advice, valuation advice from DTZ, and such advice was tabled for the board. The chairman noted the valuation advice was in fact taken into account the tenant's information, view of rental value and yields. The market value of the property is £65 million. The chairman noted that the parent had offered to purchase the property for £65 million and that such amount was consistent with the valuation advice tabled. So that's absolutely obvious. We've got a valuation, we're reading it, it says the market value of the property is 65 million, and that's consistent with the offer that we have. And then 7.1, the arrangements contemplated a bona fide commercial terms, and as such could be reached by the parties dealing arms length and in the best interests of the company. So in terms of the representation to HMRC, we have the transfer price of 65 million, according with the contemporaneous independent report, considered at the board meeting that said the market value was 65 million. Perfect basis for believing the transfer price is the market value is 65 million. And secondly, that the figure was in the best interests of Carey Street. I mean, if they're right, no claim. But if they're wrong, the transfer price had not been set by reference to the up-to-date valuation of DTZ, so Mr. Brown equally was dishonest. So Mr. Brown and Miss Leonard signed that minute as we see from page 53. The minutes show that Mr. Brown had known that he had needed to obtain up-to-date valuation from an independent valuer, as he admitted in his defence, and Mr. Brown signed a statement recording that he'd obtained one. We say, given that the judge found that no updated valuation of DTZ had been obtained, the minutes also showed the dishonest lengths that Mr. Brown was prepared to go to pretend that the transfer price had been set by reference to an independent valuation.
It sounds a bit unreal, this. I mean, I don't know what the reference in the bottom left-hand corner is. It's probably a reference for a solicitor's firm. I don't know. I dare say these minutes were drafted by a lawyer.
They were drafted by Equity Trust,
I see.
subsequent to the meeting.
Subsequent to which meeting, sorry?
So,
Subsequent to the meeting recorded here?
yes.
I see, yes.
Like by someone else who was at the meeting, other than Mr. Brown and Miss Leonard.
We think not.
So drafted by one of them.
Well, it drafted by one of the team at Equity Trust. There's
But who could only produce a minute if they'd been at the meeting, presumably.
well, yeah. I mean, it's drafted by somebody who wasn't at the meeting, which Mr. Brown then signs on the basis of what he's then provided with. I think this. They ask what the valuation is for the purpose of the minute, and they then refer to the May 2002 valuation, and the minutes drafted as if the May 2002 valuation was being relied on at the meeting as recording the valuation of as at the date of the meeting.
You've lost me slightly. They do that when? Who's they and who's? There is actually a meeting on this day. Normally, one would expect, but I don't know how it happens. There'd be some board papers, and you'd expect there to be a draft, probably a draft minute of this kind of formal decision, and papers tabled. Someone will have prepared them. Someone else in Equity Trust, presumably, with something that called itself a DTZ report.
My lord, yes, quite see that, and it's also not unusual for somebody to fiddle with the minutes afterwards. But the position here was the defendants maintained that these were genuine minutes of an actual meeting that had been prepared subsequent thereto, but accurately reflected what had happened at the meeting.
Well, I understand that, but the reason I'm just probing a little bit is the extent to which, if this was dishonest, others must themselves have been implicit in the dishonesty. And if there will have been others who will have known whether there was a report or not at the meeting, presumably. And if there was no report, they would have known that this minute was dishonest.
Well, my lord, yes. Minutes of meetings is a topic that one frequently comes across, where it is blindingly obvious that the minutes were not recorded by somebody at the meeting. They've often been passed through solicitors, for a firm of solicitors, to make sure that certain references to certain items are removed, particularly circumstances of questionable financial solvency. But that's
We've all seen all sorts of circumstances in which minutes are produced which are not
it
not
is
accurate.
yes,
but
and
we're concerned with these ones because the
Yes.
point you're making at the moment is the very inaccuracy of this minute to which Mr. Brown puts his name shows that he was dishonestly putting his name to something he knew to be untrue on this occasion.
yes,
And I'm just exploring if he knew that, who else knew that? Miss Leonard certainly.
but there's no dispute that in light of the judge's findings, this as recorded never happened.
By which you mean not that the meeting didn't happen, but that there was no valuation advice such as described.
Well,
I think the judge thought that the valuation advice being referred to was the 2002 report.
indeed. But Mr. Brown says, of course, you couldn't set the price by reference. This is cross-examination. You couldn't set the price by reference to an out-of-date 3-year-old valuation, and as is recorded in paragraph 5 of the minute, it would be a bit silly to say that a 3-year-old valuation, in circumstances where you know the market's been rising in the 3 years, is telling you what the market value of the property is as at the date of the meeting, and likewise, it couldn't be said to be consistent that an offer of 65 million couldn't be said to be accepted as in the best interest of the transfer company in the way that's recorded. There's no suggestion here, and this is the important point we come on to, no suggestion here that what had happened is what the judge said had happened, that they'd got the £65 million figure from Buckingham. And this is the point one comes on to in due course. He knows he needs to obtain an independent valuation. The judge has found that instead he took a figure from Buckingham. He doesn't sign a minute that say we've taken the figure from Buckingham. He signs a minute where the date of the 2002 valuation is left off, and it's passed off as if it was an up-to-date valuation. And the point I'll be making on blind eye knowledge, he considers not only does he know he needs to get an independent valuation, but he's so intent and adamant that he not get one, that he's prepared to sign a false minute. So the question is, why didn't he simply get one rather than perjure himself in this way? Because I'll be saying, because he wanted to save tax. It doesn't just in case you didn't do what you knew you needed to do. You're actually so intent on not getting that valuation that you signed a false minute.
And the judge's conclusion was, well, he thought he'd do it in due course.
That is, yes, we come on to deal with that, yes. So we say that it's dishonesty, it's consciousness of dishonesty, and it's an attempt to conceal the consciousness of wrongdoing. And I think I'm right in saying there's absolutely no consideration of this aspect of Mr. Brown's conduct. And I think we're directed by the respondents to paragraph 98 on page 112 of tab 7. Where the judge concluded is at the end of 98, it's more likely than not that the DTZ advice tabled at the meeting was the May 2002 report. That's it. Now that's what we say. The judge, proceeding on the basis that it was inconceivable that Mr. Brown was dishonest, just ignores the evidence of dishonesty that arises on his own findings. But we say it's not the only document that Mr. Brown signed knowing it to be false. And that was clear from a consideration of what he'd said in the Angelness proceedings. He signed a certificate of solvency for Angelness. And just to see that document, it's in our bundle, tab 71, page 268. This is for the benefit of Credit Suisse as the lender. Agreements, 2nd of August. Mr. Brown certifies the company is able to pay its debts as they fall due. And the value of the company's assets is not less than the amount of its liabilities, taking into account its contingent and prospective liabilities. And what Mr. Brown said in the Angelness proceedings, I want to look at it. We won't turn it up for the moment, but if you want to look at it, it's in the supplemental bundle, tab 7, pages 57 to 58. He said he would not have signed a certificate of solvency without first seeing the balance sheet that showed that the company was solvent. Now, he said that in a witness statement in the Angelness proceedings at a time when it was being said the balance sheet could not be found. But the balance sheet was found. So I think yes, and the balance sheet after it was found was eventually handed over, and it is in our bundle at tab 69, page 262. Yes.
So this is for Angelness.
The point being here, what one can see, that the figures are drawn up on the basis, this is the right-hand column, 31st July 2006. The figures are drawn up on the basis that the value of the property is 150.5 million, which gives net assets of just under 2.1 million. But Mr. Brown knows that the property is to be transferred at 148 million, £2.5 million less than it's recorded in the balance sheet, which obviously leads to a negative net asset position.
So,
Mr. Brown was cross-examined about this, and his answer, despite the fact that the balance sheet was provided by his solicitors on the basis it was the balance sheet that Mr. Brown had been referring to, Mr. Brown's answer in cross-examination was there must have been some other balance sheet.
what's the date of page 268?
268.
The certificate of solvency. What is that?
The first to an agreement of the 2nd of August.
2005. But the balance sheet we've been looking at is as at April 2006. Was it July 2006?
Yes, 31st of July 2006.
Sorry, yes.
And the judge deals with this point, as claims say, evidence of dishonesty.
Sorry, what's the date of page 268? Is that also July 2006?
1st of August 2006.
2006.
Is that 6 years?
2006.
2006. This is all immediately preceding the transfer away of Sampson House for 148 million, in circumstances where the certificate of solvency is being signed on the basis of balance sheet that shows if it's transferred at 148 million, as Mr. Brownsing knows it's going to be, the company's not solvent. And the judge's treatment of this appears from paragraphs 80 to 82, page 109 of tab 7. So he records in 80 to 81 the points that are being made against Mr. Brown. But then he says Mr. Brown was not, of course, cross-examined in the Angelmas proceedings, as it was only a summary judgment application, not a full trial, and it does not in any event necessarily follow that just because a witness has given an untruthful evidence in one set of proceedings, that evidence in another should also be presumed to be dishonest. As I have said, my conclusion is Mr. Brown's evidence was unreliable, it was not dishonest. But of course it factors in, it's not just a question of whether his evidence in these proceedings was dishonest, it's also a question of whether or not, as the judge found, it was inconceivable that he would be dishonest. And then obviously it isn't sufficient answer to say he wasn't cross-examined in the Angelmas proceedings, given he was cross-examined on his witness statement in these proceedings. And that then leads on to the third ground of challenge.
I mean, just before you move on, I mean, of course, if the judge really meant inconceivable, then he could have dispensed with most of this judgment.
Well, his treatment of dishonesty does indicate that he viewed it as some sort of shortcut. It's inconceivable. So I don't need to bother with the fact that these are false minutes. I can bat away the point about the certificate of solvency. I can just say that any unreliability in the witness evidence was just unreliability, despite the fact that Mr. Brown had said in his pleadings that he didn't know about the increase in the market over the relevant period, and then in cross-examination accepted that he did. The judge's approach is, I'm going to find that Mr. Brown was honest. Now, it would have been open to him to do that if, of course, he'd then assessed the instances of dishonesty and had accepted that Mr. Brown was quite capable of being dishonest, but he didn't think he was on this occasion. He didn't do any of that, just says it's inconceivable. And if that's all we had, we wouldn't be here. But it informs his approach that he refuses to engage with the evidence of dishonesty.
Did you say he was cross-examined about this by you in these proceedings?
Yes.
And what was his explanation?
Well, at the end, he just said it must have been some other balance sheet. And we had the letter from his solicitors at the time saying this is the balance sheet. Now, at the time in the Angelmas proceedings, the hearing had concluded. I think that's right in saying that. And we were pressing afterwards before judgment to get the balance sheet. Then we got the balance sheet. So he couldn't be cross-examined in the Angelmas proceedings, summary judgment application anyway. But we were given the balance sheet on the basis that that is the balance sheet that Mr. Brown had been referring to in his witness statement when he said he would not have signed the certificate of solvency without seeing a balance sheet.
And just on timing, when was that Angelmas witness statement? How long after events was that?
That would be 2000, I think it's at the end of 2013. So that would be 7 years afterwards. And again, if one looks at the email exchanges, it's not before the court, but it's all about we need to produce the balance sheets so they can sign the certificate of solvency. Then there's a sort of wobble about whether or not they do need the balance sheets, but the balance sheets are produced and the certificates of solvency are signed, and he puts in a witness statement saying the balance sheet's been lost, but they wouldn't have signed the certificate of solvency without seeing the balance sheet. And again, it may be a bit of a not the most cogent point, but even if this isn't dishonesty, it's clearly evidence of signing documents without a belief in their contents, which obviously is critical to the inquiry that the court has engaged in as to whether he had a belief that this was that the transfer prices were the market value.
Well, unless his memory has persuaded him wrongly that he wouldn't have signed it without a balance sheet.
Well, my lord, so
People can have genuine but erroneous memories.
absolutely, and again,
Are influenced by a number of things, one of which is we all like to think we did what we ought to have done, or to put ourselves in a paint ourselves in a better light. And it's not, it's, and that can lead to people giving knowingly false evidence, dishonest evidence.
Yes,
But it can also lead to the memory,
indeed,
remembering that that's what we did,
indeed.
and genuinely thinking that's what we did when we didn't.
And if the judge had said that, then obviously our submissions would be entirely different. Because the point we just made, that even if it's a situation where he says, well, I know the correspondence suggests the balance sheets were being prepared for me to read, but I don't think I would have read them, I'd have just signed it. Now that doesn't reflect very well on Mr. Brown either.
That's why he didn't say that. But,
Indeed, that may be, but the judge just doesn't deal with any of this. And none of that obviously applies to the minutes, where that is a contemporaneous statement that is false. Now, third ground of challenge, blind eye knowledge. We say the judge's findings that Mr. Brown did not have blind eye knowledge that the transfers were to an undervalue was incoherent. Given Mr. Brown's admissions and the judge's primary findings of fact, and we've addressed that in our skeleton argument, paragraphs 36 to 40. So the court can see how we put the allegation of blind eye knowledge in our re-amended particulars of claim. And we're looking here at tab 10, page 179. It's 16.2a little a. We say Mr. Brown and Miss Leonard suspected the purchase price to be paid. This with respect to Carey Street was materially less than the market value of New Court. A. Such knowledge or suspicion should be inferred as the reason for the failure of Equity Trust Miss Leonard and Mr. Brown, despite knowing that a valuation was needed, to ascertain the market value for the transfer price to obtain a valuation. Then, if we drop down to C, notwithstanding such suspicions and or beliefs, Mr. Brown and Miss Leonard deliberately and consciously decided not to obtain a valuation lest it confirm their suspicions that the purchase price to be paid by NCPL was immaterially less than the market value of New Court in order to evade the payment of corporation tax by Carey Street. Similarly, allegations in respect to Ludgate House over the page. And then if we go to page 183, paragraph 17a, we say, despite knowing or suspecting in each instance that the purchase price to be paid by the transferee company was less than the market value, the defendants did not ask for an independent formal valuation lest it confirm what they already knew or suspected, namely that the property was to be transferred at less than its market value. And it is our submission that the judge's response to that was very confused. Now, obviously, first of all, we say the judge's findings was unsustainable on this because he wrongly proceeded on the basis that Mr. Brown was incapable of dishonesty and ignored the evidence that he had been dishonest. But secondly, the starting point for the judge's consideration of these allegations should have been that Mr. Brown knew he needed to obtain an up-to-date independent valuation and could not simply rely on Buckingham. Two reasons why we say that. First of all, Mr. Brown, the respondents had said in the defence that Mr. Brown had needed and knew he needed and had obtained independent valuations before the transfer. And secondly, we say his awareness of that need had informed the misleading 18th of July 2005 minutes that we've just looked at. he thought it's so important that it appear he'd set the transfer price by reference to an updated independent valuation that he was prepared to lie and say that he had. Now, the judge held that Mr. Brown suspected on firm grounds that the transfer prices were below market value. And we've got that at the judgment 128129, page 119, tab 7. And if you could look at that, this is a, what looks at that, 119. Sorry, yes, page 119, paragraphs 128 and 129. It says, as I've explained, it must be shown Mr. Brown had firmly grounded suspicion that Newcourt was worth more than £65 million. He deliberately refrained from taking any action to confirm his suspicion. Then I have already found that Mr. Brown was aware of the possibility that Newcourt could be valued at a price in excess of 65 million. The property was, for example, shown in the ISR asset statement at a value of 70 million. In addition, the clear purpose of the project Ocean refinancing, as far as Newcourt was concerned, was to increase the level of borrowing, which would in turn be dependent on Newcourt being valued at more than 65 million. And just that was the point that Lord Justice Popplewell raised with me. The 65 million wasn't going to be used for all purposes. And he says, I would accept on this basis that Mr. Brown's suspicion was firmly grounded on specific facts known to him. And then, with respect to Ludgate House, it's at page 144, paragraph 254. As with the case in relation to Newcourt, I accept that Mr. Brown would no doubt have had a suspicion, based on his knowledge of the total price paid, the public valuation of 80 million produced for Project Ocean, and his understanding that property prices have increased since then, the transfer price was less than the market value of Ludgate House.
Sorry, Michael, I'm going to read it slow, but 129, the clear purpose of the Project Ocean refinancing was to increase the level of borrowing, which would in turn be dependent on Newcourt being valued at more than 65 million. But
Yes.
it had to be valued at more than 65 million in order to make the Project Ocean refinancing valid, didn't it?
Yes. But it's not therefore a situation.
It was only valued at 65 million.
I'm sorry, that it was valued by Colliers at more than 65 million. That value was 72 million came in 2 days after the transfer. But at the date of the transfer,
If it was valued at 65 million, that was sufficient for the purposes of the Project Ocean refinancing, wasn't it, or not? I mean, that's what it was valued at, and the refinancing went ahead, didn't it? Is that, I misunderstood that?
well, at 129, the judge is recording that for the Project Ocean refinancing to go ahead,
It needed to be more than 65 million.
you need to be valued at more than 65 million.
That's how I was reading it, but
Yes.
I was a bit perplexed by that.
Sorry,
Given that it was in fact valued at 65 million and the Project Ocean refinancing did go ahead.
well, well, that is our point. We say it wasn't valued at 65 million in 2005 on the basis this is the market value. The figures put on it on the basis it's a figure appropriate for the purpose of the transaction, at the same time as we intend that there also be obtained a valuation at more than 65 million that we're going to use to get refinancing.
I see. So
This is an
65
example.
was not used at all for the refinancing.
This is why 65 million is not
It
used.
was not
Yes,
used
not
in
used,
any way
yes.
in the refinancing.
Correct.
I see. I understand that.
And we say this confirms our basic point that the figure changes according to the purpose of the transaction. And then at 254, the second half goes on, having said he had firm suspicions that the value was more than 178 million, He says, however, there's simply no evidence that Mr. Brown consciously refrained from getting an up-to-date valuation, independent valuation, for fear it might confirm his suspicion. On the contrary, he was told that the valuation had been obtained from Buckingham, and he relied on that advice. And we have highlighted the fallacy of saying the reason why he didn't do what he knew he needed to do is that he did something else. It's the doing of the something else that leads to the question of why you didn't do what you needed to do. It's not the answer to it. So Mr. Brown has admitted that he knew he ought to have the property valued. The judge has held that Mr. Brown suspected that the valuation that he knew he needed to obtain would have resulted in a higher transfer price. We say the judgment shows that Mr. Brown had chosen a transfer price appropriate to the purpose of the transaction, namely at the lower end of possible figures, because he wanted to pay less tax. Mr. Brown therefore knew that if he had the property valued, more tax would have to be paid than Mr. Brown wanted to pay. So ergo, we say, Mr. Brown did not obtain the valuation for fear it confirmed his suspicions and he had to pay more tax.
There's a gap in the reasoning, isn't there?
Oh.
I mean, I quite follow that that could be the reason he didn't do it, but it's not the only possible reason.
My lord, absolutely. I mean, this is what we come on to. That's just simply on the basis of those being the facts. We say, absent anything else, ergo applies. We say it's difficult to see, absent anything else, it's difficult to see what more a judge could have wanted by way of proof of Mr. Brown's reason for not obtaining a valuation, being his concern a valuation would come in at a higher figure and more tax would have to be paid.
Well, can I take New Court, which is because CSI, as I understand it, there's no suggestion it was insolvent at the time. For whatever reason, possibly because there was a hurry, they haven't got the valuation by the time of the meeting. There was some hurry, wasn't there, because they needed to sort it out for withholding tax purposes.
Well, I think...
But anyway,
yes.
assume that for a moment. So he gets as far as the transfer. They settle on a price. He's told by Buckingham it's fine. It's only a transfer within the group anyway. Yes, he thinks, well, I should have got a valuation earlier, but, you know, it's water under the bridge now. Why isn't that a legitimate inference? Or indeed the more obvious inference?
That he makes no effort to get a valuation when he could.
He hasn't got it in time, but it's all water under the bridge. The transfer's happened. It's only within the group anyway. Well, why should we spend money getting a valuation now?
Well, it's the judge who says.
No, he suspected that he suspected if he'd got a valuation, it would have been a higher price.
Yes.
But that it doesn't follow from that that's the reason he didn't get one after the event when the transfer had already happened.
No, sorry, you misunderstood my submission. Mr. Brown's pleaded case is that he needed one to get one before.
Yes.
So we're just concerned with the pleaded case that he knew he needed to get one before.
You mean you infer that he would have got one in time for the transfer?
Well, we'd have to put if you forgive me.
Yes.
We come on to the judge's suggestion about getting one after the transfer. But for the moment, dealing with the pleaded case and putting aside one's responses to the judge's point about, oh well, he thought he was going to get one afterwards. He knows he needs to get one.
Yeah.
Now, obviously, the price for Carey Street is fixed, I think, the 21st of June, long before the actual transfer. Now, obviously, if you sit around and not get what you need to get, there may come a point at which, if you suddenly changed your mind, it would be too late. But we're not talking about that. He's had ample time to get one, and his defence is, oh, but I did get one.
Okay, so let me try it differently then, having adjusted my perception. So he knows he ought to get a valuation and he negligently fails to do it. Since on this hypothesis he knows there's a range of figures, obviously he's aware that there's a risk that if he gets a valuation, it's going to be higher. But why isn't carelessness the more obvious inference than deliberately failing to get one for fear it's going to come out higher?
Because negligence in my submission would be appropriate if he says I wasn't aware of the need to get one. I can quite accept looking back that I ought to have been, but I wasn't aware. But he says, no, I knew I needed to get one. I was aware of what was required. So why didn't you do it? No other reasons put forward other than that it enabled him to save tax.
Well, he didn't put forward that reason, as far as I know.
Sorry, what?
I don't think he put forward that reason.
No, absolutely. But the evidence is the only, we are saying it's an obvious reason, given his acceptance. The admission that he knew he needed one.
That's what he said in these proceedings. It's not what he said in the early proceedings, is it? He said in the early proceedings it wasn't his
Which wasn't in evidence in these proceedings. And that comes on to my fourth challenge. What they said in these proceedings. For the moment, I'm saying there was never any withdrawal of his admission that he needed to obtain, I'll say, a proper valuation before the transfer, and that he was aware of that. Hence his defence, but I got one.
And
Now-
then you say, and also what you say is the suspect minute.
And yeah, indeed, which we
Why,
said.
why bother, you'd say, with
Why-
the suspect minute?
Yes. And I'm just saying that the other things that the judge said about him being rushed, getting one afterwards, he never said any of that. And we say it doesn't stack up when you look at the documents. Plenty of time to get a valuation. And the fact that when at the last minute it said, well, it's all now a bit urgent, isn't an answer, wasn't put forward as an answer. So why, knowing what's required, why did he not do it? And as I'm very helpfully reminded, was he so aware that he needed to do it that he lied and pretended that he had? And we say the only suggested reason was that he wanted to save tax. And obviously, this couldn't be explored with Mr. Brown in cross-examination because he was insisting he'd set the transfer prices based on an independent valuation. So why didn't you get it? Why didn't you get an independent valuation? And I did. You just can't. It can't be explored in cross-examination because of the nature of the defence. So I'm simply left with what we say is a very basic point about human nature. If a person suspects that doing something he knows he ought to do means he can't do what he wants to do, then that suspicion is the most probable explanation of why he did not do what he knew he ought to do. Bit of a mouthful, but I hope I got through. And we say rather than accept that this axiom applied in the circumstances of this case, rather than grapple with the axiom, the judge simply came up with explanations for Mr. Brown's not obtaining evaluations that had never been put forward in pleadings or in evidence. Now, we'd also point out, before we come on to that part of it, that the judge's analysis on the issue wasn't helped by the questions that he asked himself, as set out in paragraph 91, tab 7, page 111. Paragraph 91, the judge says, the issues which the court must determine, did Mr. Brown have available to him an up-to-date independent valuation of reason? The answer to that, no, he didn't. 91.2, if not, did he nonetheless consider the transfer price of 65 million reflected, there's that word again, the market value of the property? But then he goes on to the third question, even if he did he have a firmly grounded suspicion that the market value was higher than this, but deliberately refrained from obtaining an up-to-date independent valuation so that his suspicions were not confirmed? But one, in our submission, what one would rather have expected the judge to say, if he didn't consider that the transfer price of 65 million was equal to the market value, did he have a firmly grounded suspicion that the market value was higher than this? And did he refrain from obtaining an up-to-date independent valuation so that his suspicions were not confirmed? Because the way the judge frames it, the judge in effect says, if he believed, this is obviously subject to the qualification that, of what the judgment actually decided, but he's saying if he believed the transfer price of 65 million was equal to the market value, then the judge supplies a reason why Mr. Brown wouldn't have bothered getting a valuation. Well, they ought to get one, but I think I believe this to be the market value. So I'm not at risk with the HMRC. I'm not misleading anybody. I'm taking a shortcut, but that doesn't involve any dishonesty. What he should have been saying, well, if Mr. Brown didn't believe it was the market value, given that he knows he's going to make a representation to HMRC that he believes it was the market value, why didn't he get the independent valuation that would have enabled him to make a truthful representation, which Mr. Brown admits he knew he needed to obtain?
Would blind eye knowledge be relevant if the judge had concluded, in answer to the second of the questions, that he didn't think it reflected the market value? That would then have been knowingly untrue. We wouldn't be into recklessness or blind eye knowledge, would we? I read it was phrased there to be phrased in your favour, that if the answer to 2 was you didn't consider it reflected the market value, and end of. But you didn't stop there if the defendant succeeded on that point, because you still then had to deal with blind eye knowledge. I'm not quite sure what you're saying is wrong with that structure.
Well, 91.3 should be if he did not.
If he didn't consider it was the market value.
Well, if he didn't consider the point,
End of, isn't it? It's
no,
knowingly untrue.
No, we say, yes, we say we get home on the transfers at an undervalue because of the dishonesty as against HMRC. Yes, but it's not therefore knowledge that the 65 million was at an undervalue. We say 91.2, we've established that he did not believe that 65 million was equal to the market value. Our claim succeeds because of the dishonesty as against HMRC. But that's not a finding. He didn't believe it was 65 million, but it's not a finding that he believed that the actual market value was more than 65 million. And we need that, or it certainly improved our position, and is solely the basis on which we present the appeal with respect to the dividend payment and the 776 that's left outstanding. Because if he has knowledge that in fact the market value is in excess, and this is relevant, if it is in excess of the figure at which it's been transferred, the two consequences are, when one come on to the dividend, he's suppressing a liability to HMRC. And secondly, when one then comes on to consider the position of Ludgate, he knows it's an insolvent, he knows that 245 Blackfriars is an insolvent company. That's the additional relevance to the claims of going further and saying, it's not just he didn't believe these were the market values, which gets us home on transfers to the value. He also had blind eye knowledge that the transfer prices were below the actual market value, and that has consequences for the other claims.
Can I just try to understand? So suppose 91.2, you conclude that the transfer price reflected, accorded with the market value of the property. What, if any, claim are you left with on your case?
Well, we say we're still left with a watered down blind eye knowledge case. We're still, if he knew, if he believed it to be the market value, then the claim with respect to HMRC falls away. And the blind eye knowledge claim, which because this then becomes an unlawful distribution, it's still theoretically in play. Now we accept if a person is found to have believed that the transfer value was the market value, the blind eye knowledge claim becomes more difficult.
So, as you're presenting it, the judge would have been right to think about blind eye knowledge in that scenario.
Well, yes.
But you say he ought to have thought about it in a different context as well.
Yes, because of course, Mr. Brown has said, I can't know what the market value is if I don't have a valuation. His defence is, expressly, I don't know enough to know what the market value of the properties is. I obtained independent valuations because I knew I needed them. Now, if he didn't obtain the valuations, then it follows that he didn't believe the transfer prices were the market value. And then you go on to consider, well, is the reason he didn't get the valuations because he feared if he did, he'd have to pay more tax? And the judge has found, yeah, he had a firmly grounded suspicion that the transfer prices were below market value. So on that basis, it's a fortiori that he knew he needed to obtain market valuations. So why didn't he get them?
And that indeed is where you get to. And then the question is, was the judge wrong to think that he failed to get them for an innocent reason? Perhaps negligence.
Yes, yes.
And there you have to overcome the finding of fact.
Yes. Well, this really largely feeds into the point about a pleading. It's because the judge comes up with two ideas that were not floated during the course of the trial. And there are ideas that, in our submission, do not withstand a moment's scrutiny, a scrutiny to which they were not subjected because they only came out with a judgment. Which obviously feeds into the first point, the fundamental unfairness of a case being decided on the basis of the points that were never pleaded. So as this sort of leads on to the point I think I'm at, I say I've made the point, and this in terms of, well, what was the reason? And this is the point about the minute that Lady Justice Asplin has got. The reason he didn't obtain a proper valuation must have been a very substantial one, such as the financial advantage in not paying the tax that he suspected he would have had to pay if a valuation were obtained. And that is because if it hadn't been a substantial reason, if he hadn't had a substantial reason for not getting one, he would simply have got one rather than sign the false minute. And the judge doesn't grapple with the consequences of Mr. Brown's dishonesty with respect to the minutes, and he doesn't grapple with the question as raised on the pleadings. Instead, he comes up with his own explanations as to why Mr. Brown had not got a valuation. So the judge said, in both instances, Mr. Brown had simply run out of time. 132256. But that was not pleaded. It's not what Mr. Brown said at any point. And factually, it doesn't bear scrutiny, the scrutiny it would have received had it been pleaded. So Ludgate House, we've seen the email exchanges about the transfer price. We've seen the suggestion that they go to Collier's to get one, but they didn't. The price for New Court was settled at 65 million. Had been settled at 65 million by the 21st of June. The solicitors are corresponding on the 21st of June on the basis the transfer price is to be 65 million. Mr. Brown, in cross-examination, accepted the honest, sensible course. You get your valuation so that you know what the transfer price is. It's obvious. If there's no other considerations, as they shouldn't be, you get your valuation. But no, they set the 65 million. They do that by the 21st of June. There's still time to get a valuation. And that's the document we put in at tab 38, page 168, that shows it's 21st of June. So the judge, with all respect, the judge was simply inventing defences for Mr. Brown, consistent with his view that it was inconceivable that he'd been dishonest. And then for New Court, and New Court alone, the judge found that as far as New Court was concerned, there was an intention to obtain a valuation after the transfer at 65 million had already taken place. We've got 7 points on that. The first is, it wasn't pleaded. The second point, it does not of itself provide any answer to the question as to why Mr. Brown did not obtain a valuation before the transfer, as he knew he needed. And it relies on the suggestion, the previous suggestion, that Mr. Brown ran out of time to get one before the transfer had to be addressed. Thirdly, it wasn't Mr. Brown's evidence. Fourthly, no such valuation was ever obtained. The judge did not address why, if there had been intention to obtain a proper valuation afterwards, none was ever obtained. Fifthly, the judge did not address why, if there had been an intention to obtain such a valuation for New Court, there was no such intention for the Bankside estate properties. Sixthly, the judge did not explain how this was said to negate the dishonesty with respect to the representation to HMRC. It was never suggested that the representation that 65 million was believed to be the market value and in the best interest of the transfer company would not be made unless a valuation at that figure was obtained. Pausing there, if the answer had been, it would have been ideal to get a valuation, I couldn't get one, but there's no way we would have allowed the representation to be made to the HMRC without informing them that it, in fact, well, I wasn't backed by a valuation and we got a valuation that was a higher figure. But that's none of that. It's 65 million based on the transfer price, and that's it. It's a representation to which any subsequent valuation would be irrelevant. Seventhly, the judge did not address what would happen if a valuation at that figure could not be obtained. As I say, none of that's investigated at trial, but none of it was pleaded or floated. So one is left with no reason for the transfer prices not being set by reference to independent valuations, other than the obvious reason, namely Mr. Brown's desire to save tax. And the only reasonable conclusion is that on the balance of probabilities, the reason why in each case Mr. Brown had not obtained valuations was lest it resulted in higher transfer prices and having to pay more tax. Mr. Brown thus had blind eye knowledge that the transfer prices were less than the market value. And that leads on to my final challenge to the decision on the transfers and the market value.
I'm sorry to keep holding you back, I know you're under pressure of time, but you referred us, gave us a reference to the 21st of June document, tab 38.
Page 168.
168.
Yes.
Which I just turned up. I'm not sure I've understood. It's dated the 21st of June. It's from Peter Taylor at Allswangs. What was Allswangs' role? Were they also advising, but on the financing side?
I think they are also advising equity trust, yes.
On the financing side, or and it's addressed to Elizabeth Sweeney. I wasn't quite sure who she was.
Sorry, my understanding is that this is an email between the solicitors.
It's from Peter Taylor at Allswang,
Yes.
and it's to someone else within Allswang, is it? Or
No, I'm thinking this is Elizabeth Sweeney at SG Berwin. But it's my understanding is a solicitor letter Hence, sorry? Oh, yes, Sweeney, Sidley, Austin, yes. Sorry, Elizabeth Sweeney, Sidley, Austin. They're acting for financiers. Yeah, they're acting for the financiers.
Okay, so this is in the context of the financing.
Yes.
Peter Taylor says, I'm now instructed that paragraph of consideration for the transfer should be 65 million.
Yes.
So that is the figure that's being used at that
Oh,
stage.
it is.
For the
Yes.
financing. And the
No, yeah, so,
I think the content goes on to talk about that being used both in the transfer documentation and in the financing documentation.
this is in the context. I'll come back to it tomorrow if I may.
Yes, if it's
My
more convenient.
my understanding, this is in the context of the existing finance that's going to be paid off. I apologise if I'm wrong. And that's why Sidley Austin's involved, because the existing indebtedness is going to be paid off from the proceeds
They're
of
not,
the transfer.
they're not Credit Suisse's rights there.
Yes, this is not Project Ocean. This is existing indebtedness that's going to be paid off from 65 million. And as we see, that transfer price is being fixed 21st of June. And the transfer didn't take place until the 18th of July.
You say it's been fixed, and that's what's been identified at that stage, but there's no reason it couldn't be changed, was there?
Not at all, but
You were portraying this as though they've said 65 now, they're stuck with that, and then
No.
then once a month has gone by, they've got to find some justification for sticking with this.
Well, no, my 2 points are, as Mr. Brown accepted, the more sensible course would have been to obtain a valuation before you decided on the transfer price. This is for the purpose of showing that if the transfer price is still subject to the need to obtain a valuation, which Mr. Brown's saying, there was still time to get a valuation and then go, so actually it shouldn't be 65, we've now got a valuation at whatever the figure is. But the notion that they simply didn't have time, it doesn't make sense, because here we have, they picked 65 million, they've still got in excess of 3 weeks to get a valuation. This isn't the case basically of saying,
I think I understand that. It's when you say,
They woke up one day-
they fixed it at 20.
yes, they did wake up
That's
one day and
65
say,
million. They've chosen 65 million at this stage.
yes.
But
The,
I understand your submission.
the urgency is self-inflicted. They don't wake up and say, gosh, we need to transfer it within 4 days because of tax considerations. They're spending weeks on this, and it may be you eventually get to the point, well, we can't mess around with this any longer. But in all that time, no suggestion that anybody's going to get a valuation.
I understand what the purposes of the
Yes.
phrase.
I'm not open to the judge to make findings that he did on the pleadings. He should have determined the case on the basis of the issues identified in the statements of case, and on those issues, the appellant clearly unambiguously succeeded. And we also say not open to make findings he did on the evidence. We took the liberty of just drawing to the court's attention a case which no doubt the court was already aware of, the recent decision of this court in Clement and Siddle, which sets out relevant principles when considering the paramountcy of the statements of case. And obviously we commend those to you. Now, I have already, during the course of making my submissions, highlighted a number of very important respects in which the judgment departs from the party's pleaded case, which obviously I rely on for this challenge. So I've just highlighted how the judge invented reasons for Mr. Brown not obtaining the valuations he said he needed and was insisting that he had obtained. I've also highlighted how the judge's treatment of market value as a flexible concept entitling a person to put forward different figures as to what the market value is according to the purpose of the transaction is not something that one finds in the pleaded case. And again, questions of dishonesty, we say, are answered by his admission with respect to what the terms of the representation was, and the matter couldn't be taken any further because Mr. Brown's position was that he had obtained the evaluations. But we say in addition to those failings, the judge also proceeded as if, entirely contrary to the respondent's pleaded case, Mr. Brown had not in fact thought that he needed a valuation from a valuer before the transfer, and as if Mr. Brown had thought it sufficient for whatever belief he had with respect to the transfer prices to be based on guidance from Mr. Sirrah of Buckingham, who, as Mr. Brown recognised, was neither independent nor a valuer. And on that basis, the judge held Mr. Brown to have acted honestly, but we say, given the respondent's pleader's case, it was not open to the judge to so find on that basis. Now, the court would appreciate that the respondents were advised throughout by a highly respected firm of solicitors and experienced leading and junior counsel. The position adopted by the respondents with the benefit of that advice was not that Mr. Brown was unable to plead to the allegations and therefore was relying wholly on non-admissions. The respondents chose to admit many of the allegations in the appellant's statement of case and gave their reasons for denying other allegations as required to do so by CPR 16.5. The respondents had all the documentation available to them, including Mr. Brown's witness statements, in the Angelmas proceedings. They chose to put forward a positive defence that was inconsistent with the version of events that had been run by Mr. Brown in the Angelmas proceedings, in where he said he'd relied on Buckingham. Now that was a conscious decision taken by the respondents with the benefit of legal advice. And in the pleadings, therefore, the respondents admitted that Mr. Brown knew that he needed to obtain a contemporaneous valuation as at the date of transfer, and averred that he'd obtained them. So you need to get a valuation before the transfer. Now, if we look at our pleadings in this respect, tab 10, page 178. Again, the bottom of the page there, we said paragraph 16, subparagraph 2. Mr. Brown and Miss Leonard knew that B, the transfer would be an event giving rise to a tax liability assessed by reference to the market value, and the representations pleaded, subparagraph would be made. And then B(2), the purchase price ought to be the market value as ascertained by a contemporaneous independent formal valuation at the date of the transfer. And third, the purchase price was not being set by reference to such a valuation. We say this is clearly an allegation that the transfer price needed to be set by reference to an estimation of the actual market value carried out by a professional valuer. And therefore, if the defence was intended to mean something different by use of the word valuation, then the defence needed to make that clear. But in fact, when one looks at the defence, it was equally clear that the defence was responding on the same basis, namely that a valuation connoted the opinion of a professional valuer. So if we then go to the defence, which is at tab 11, and we go to page 209, this is the paragraph 14 that is always referred to whenever there's a denial in the defence. You see there, top 209, paragraph 14, well, as regards New Court, Mr. Brown was aware of the need to obtain an updated valuation of the property before Carey Street sold to NCPL. No suggestion that they're referring to anything other than a proper valuation by a valuer. Then goes on, as we see, then goes on to plead that an updated valuation was in fact obtained, namely from a firm of valuers, DTZ. Paragraph 14.2, respect to Ludgate House. Again, Mr. Brown was aware of the need to obtain an updated valuation of the property before Blackfriars sold Ludgate Properties Holdings. And then they go on to say, unable to locate such a valuation amongst their records. appropriate to infer that an updated valuation was obtained and described a value of 78 million. The grounds for this inference are, first of all, the subparagraph immediately above, namely, Mr. Brown was aware of the need to obtain an updated valuation. We're talking about a document that they're saying there's a document that is missing, it can't be found, but you infer that there was one because Mr. Brown was aware of the need to obtain an updated valuation. Secondly, they rely on the fact that the DTZ letter was obtained, again, from a valuer. And thirdly, the inherent likelihood of the directors of Blackfriars obtaining an updated valuation for Ludgate House. And then it says, in the circumstances in which it was to be transferred. And bear in that mind, in the circumstances at which it was to be transferred, because that features in Mr. Brown's answers under cross-examination. And then if we could please go to page 215. Paragraph 28 to G, there's the response.
To paragraph 16.2.
16, page 215.
Sorry, but this is the direct response.
Yes, sorry.
To the pleading that you showed us in the statement of
Your Lordship's ahead of me, sorry. D, the allegation was Mr. Brown did not set the property by reference to an independent contemporaneous independent formal valuation. And the allegation is denied at D because paragraph 14 is repeated. They don't say it.
Well, but before we get there, I've got my finger in page 178. Roman 2 was the allegation that the purchase price ought to be the market value as ascertained by a contemporaneous independent formal valuation.
Yes.
And it's C which
yes
addresses that.
And says
which says we don't know what you mean by independent formal valuation.
Yes, come on back to that.
We do admit that it has to be the market value.
But D, subparagraph 3, is denying the allegation that it wasn't set by reference to such a valuation. So I mean,
because
so you strip away
that has within it the cavil about it needing to be a
independent
formal value.
Indeed. But there's no cavil about the fact it should be from a valuer. And the reason why that's there, my lord, again, we have the document, the DTZ letter that they said was the contemporaneous valuation is a letter with manuscript annotations on it that is not addressed to Carey Street. It's addressed to the holding company, and it is so heavily caveated, insisting that no decisions be made on the basis of that letter, that it would be difficult to describe it as an independent formal valuation. But it was at least from a valuer. This is the point we would emphasise. There was a dispute for a brief while as to whether or not they were saying the valuation needed to be an independent valuation, and we'll see that. But there was never any dispute that it needed to come from a valuer. And we say, therefore, when one reads this defence in light of the state claim, there couldn't be any serious suggestion that this should be taken as a reference to an oral opinion from Buckingham. And we say...
You may be right about that in the way it was further clarified or was a matter of evidence, but I don't, speaking of my own part, see that you get that out of subparagraph C or subparagraph D at page 215. You just don't get the admissions that you're suggesting are there. It just has to be an independent valuer whose job is independent valuations.
No, look, we can let's say, forget independence and forget formal. You've still got the pleading of it being a valuation, which in my submission clearly connotes it's the opinion of a valuer and not simply the opinion of a non-valuer. In normal common parlance, particularly in the context of a legal document such as this, one would be surprised to learn that the pleader was using the word valuation in referring to the opinion of a non-valuer. Now, we've used it quite clearly as being a reference to a professional valuer, and they have come back and said, well, we think your use of independent formal is vague.
Independent formal valuation.
Yes.
embarrassingly.
Yes, but they still use the word valuation, so they don't have a problem with the word valuation. And we say, if they were going to say, well, actually we mean the oral opinion that was given in Buckingham, they should have said that. And of course, we then see that when they're saying they got a valuation, they are indeed referring to a valuation from professional valuers. So this is just inconsistent with any notion that what they were intending to plead and what we should reasonably have understood that they were pleading was reliance on an oral opinion from a non-valuer. And again, Ludgate House, they said, we can't find it in our records. But not, well, it may have been oral, we can't find it in our records, but it should be inferred that there is one because we got one from DTZ for Carey Street. And then I make the point that this paragraph 14 is the only positive defence that's raised. Nothing else. Now, as I said, the defence was on the basis that independent valuations had indeed been obtained, but it was noted that the defence didn't expressly acknowledge that the valuations needed to come from an independent valuer. And there was the cavil that your lordships pointed out. That anomaly was the subject of a Part 18 request from the appellants. That's in the appellant bundle, pages 25 to 26, if the court wants to look at it. But the answer that we got was that we should await the evidence, whilst reiterating that Mr. Brown knew the purchase price should be the market value. So we say, what's your pleaded case? They say, wait for the evidence.
And just give me the reference again.
It's pages 25 and 26. And we got the evidence, and that is Mr. Brown's witness statement, which we have in the supplemental bundle, page 43. Now, obviously, Mr. Brown said he obtains a valuation from DTZ before the transfer, that's Carey Street. Then, considering the position with Ludgate House, page 43, on tab 3 of the supplemental bundle, he says at paragraph 87, as with New Court, I would not have approved the transfer of Ludgate House to Ludgate Properties Holdings without a valuation of a similar nature to the valuation for New Court. And at 88, I'm aware no valuation for the hive of Ludgate House has been found, but I'm confident there would have been one because I would definitely have needed to see it. Then we say, but 87 is clearly confirmation that he's talking about a valuation from a valuer.
Just give me the reference in the witness statement to what he said about value in relation to New Court.
Oh, sorry.
We'll do it in the morning if you'd like.
I'll do it. Thank you. Cross-examination then. This is in our additional bundle. It's at tab 8. Tab 8, page 38. It's on page, internal page 2, on page 38, line 25. I get straight into it, and it goes through to page 4, line 13, if you'd be so kind as to read that.
Yeah.
So we had Mr. Brown clarified that we were understanding what he said in his witness statement correctly. There was then a period of confusion, and in particular, my learned friend relied upon this in closing. If we go to page 16, we see Buckingham. This is, I think, where Buckingham's introduced as a possible source for figures on valuations.
That comes in
I'm sorry,
before that.
We've been told about it, page 5, haven't we?
No.
I mean, he doesn't accept that it would necessarily be from an independent expert such as DTZ, bottom of page 4.
No. Indeed.
And he says it might be from
Indeed. Yes.
C line 11. Sometimes we had Buckingham we'd use then.
Indeed. And then the passage that I picked up in the circumstances of the case from the plea of defence, paragraph 14, and we see on page 16, internal page 16, page 41, picking up at line 6, I say, so you were saying that sometimes you wouldn't actually get a valuation from Buckingham, you would simply run discussions with Buckingham. Answer, there's ongoing discussions with Buckingham all the time, so we generally knew the value of each of the properties in the portfolio. But it would depend on the transaction or the nature of the reason for the valuation. So, depending on the nature of the transaction, in certain circumstances, you could rely on Buckingham. And then, page 19, line 22.
So give me that page again.
19, line 22, through to page 20, line 21. So to paraphrase, initial confirmation, then Mr. Brown introduces the notion of getting valuations from Buckingham, depending upon the circumstances and the particular transactions. The judge very helpfully then brings clarity to what Mr. Brown is saying, because Mr. Brown confirms, for a transaction like this, they knew they needed to get an independent valuation. And he repeats that at page 26, lines 18 to 22, and page 27, lines 5 to 6.
So what were those references?
Page 26, lines 18 to 22. This is on page 43.
Yeah.
And page 27, lines 5 to 6. So it is our,
Yes.
So it's our submission that on a proper reading of the defence, he was referring to a proper third-party valuation. And that is confirmed in his witness statement and is repeated in cross-examination, which of course accorded with what the minutes for the transfer of New Court had said. Namely, it's not simply thought desirable to set the transfer price by an independent valuation. It was necessary. One could not set the transfer price by lesser means. And the defence also made clear that Mr. Brown's alleged belief that the transfer prices were the market values was based on the independent valuations he claimed to have obtained. And the clearest examples, if we go to the defence, tab 11, the call bundle, page 214, it's paragraph 27, subparagraph 2. had there, Mr. Brown says, Mr. Brown believed the consideration payable by the transferee company for Newcourt and Nudge's house to reflect the value of those properties, paragraph 14 above, is repeated. That's the paragraph saying, I knew I needed to obtain valuations and I obtained them. And then at page 225, paragraph 49.2, say that for the reasons pleaded, this top of page, no false representations have been made by Carey Street directors to HMRC. Further, alternatively, it is denied it would have been dishonest for Mr. Brown and Miss Leonard to have B, continue to operate on the basis of their genuine belief, brackets, based upon the DTZ letter as amended, that Newcourt was worth 65 million as at July 2005. And this is dealing with events at the time of the payment of the dividend. So there's no alternative basis for that belief pleaded. And that's something the judge recognised at paragraph 102. So the position is that the respondents were accepting their defence. Mr. Brown himself could not know what the market values were. That's paragraph 28, that's paragraph 6 and paragraph 57. That Mr. Brown knew that he needed a valuation from a valuer, and Mr. Brown was asserting the transfer prices have been set by reference to independent valuations, and that based on those valuations, Mr. Brown believed the transfer prices were the market values. Now, as I say, the witness statements accorded with his defence. Just to say, I'm conscious of the time, sorry. Mr. Brown said at the outset of his witness statement, he had reviewed what he had said in the Angel Miss proceeding, but he at no point endorsed or verified what he had said in those proceedings, and he then proceeded to give evidence that flatly contradicted what he'd said in those statements. The essential point was what he'd said in the Angel Miss statements was not his evidence. We say, therefore, it wasn't open to the judge to hold that Mr. Brown had honestly thought he could rely on the opinion of a non-valuer. It's not simply that that is not what Mr. Brown said. Paragraph 14 of the defence, Mr. Brown said that he had known that nothing other than a proper valuation would suffice. Mr. Brown was saying he could have no other defence other than obtaining an independent valuation. Relying on anything else would have been a conscious breach of the fiduciary duty to obtain an independent valuation that the judge found him to have broken. That's subject to his observations earlier. And so finally, before considering what the judge said on this, which will be tomorrow unless I'm directed to continue, the judge should have proceeded on the basis that any defence that Mr. Brown honestly thought it was acceptable simply to rely on Buckingham was, 1, evidentially inconsistent with the minutes for the Newcourt transfer, 2, was never even suggested for the Newcourt transfer, and thirdly, as for Ludgate House, had never been pleaded and was not consistent with paragraph 14 of the pleaded defence and his acceptance in the witness statements and in the witness box that he knew he needed to obtain independent valuations. If that would be an appropriate moment.
That would. Can we just review where we are? I was saying first thing this morning that you needed to sit down by 11:30. You've got a way to go, haven't you?
I'm afraid I have.
Can we just confer one moment? Do we just say whatever? Shall we say one? Mr. Barker, I think we're accepting that our optimism earlier was misplaced. And so while we would like you to proceed as quickly as reasonably possible, we would accept that if necessary, you go to lunchtime tomorrow.
That's very kind. Thank you.
So we'll break now and start again at 10:30 in the morning.